Good afternoon, everybody, and welcome to our second Faculty Masterclass of Reunion Weekend. I hope that many of you were able to join Professor Lebmore and Professor Rowan's Faculty Masterclass this morning that focused on troubled cities. I know that many of you took classes with Saul and Julie while you were students here at the law school, and I hope that you enjoyed hearing from them once again today. This afternoon, we're in for a real treat. As you may recall, if you joined me for yesterday's State of the Law School presentation, we were fortunate to welcome 5 new faculty members to the law school at the beginning of the academic year. And we're lucky to have one of those new faculty members, Professor Bridget Fahey, presenting to all of you today. But before I turn things over to Professor Fahey, I hope you'll indulge me while I brag a bit about her credentials. As I noted, Professor Fahey joined the law school last fall as an assistant professor of law, teaching constitutional law and contract law. Her research focuses on the theory and practice of American federalism, especially the forms of intergovernmental interaction, joint lawmaking, and collaborative governance that challenge the traditional paradigms of federal-state interaction. Before joining the faculty, she was a litigator in the Washington, D.C. office of WilmerHale, a fellow at the University of Pennsylvania Law School, and a law clerk on the D.C. Circuit and on the Supreme Court of the United States for Justice Sonia Sotomayor. Of course, given these tremendous achievements, it's no surprise that Professor Fahey graduated from the University of Chicago with a BA in political science in 2008. I wish our law school could claim her as one of our graduates, but that distinction belongs to Yale Law School, from which she graduated in 2014. Today, we're delighted to welcome Professor Fahey to our Faculty Masterclass series to present a talk entitled Federalism Big Data. I'm always pleased to introduce to our alumni our newest faculty members, and I'm so grateful to Professor Fahey for speaking with all of you today. I hope you'll give her a warm Chicago Law welcome and enjoy hearing from her. And with that, I turn things over to Professor Fahey.
Well, thank you for that very kind introduction, Tom, and to the coordinators of Alumni Weekend, and to everyone who's joining me for this talk. I wish it could be, as I know we all do, in person, but I hope we can make the most of this virtual context also. So this talk is about an ongoing project and a forthcoming article called Federalism Big Data, and it explores the legal implications of one of the many ways that governments have mimicked a trend of note in private markets. So private data markets in which firms buy and sell data sets have really propelled explosive data aggregations. And they've also pressed profound questions about privacy and corporate power and government regulation. This project argues, though, that data markets aren't for the private sector alone. And in fact, our various domestic governments, the federal government and states and cities, have begun to aggregate vast data stores themselves, not just by collecting data directly from individuals, but even more efficiently by purchasing data in compilations ready-made from their sister governments. So when the federal government wants data for one of its policy programs, it can first consult state governments and see if in their DMV databases or social benefit stores or policing records, they might already have the relevant data. The two governments can then agree on an exchange. They can exchange data for other data, they can exchange data for money, or they can exchange data for policy commitments. So the Secure Communities program during the Obama administration asked the states to turn over data relevant for federal immigration enforcement. And in exchange, the federal government offered what were effectively certain policy commitments, commitments to use that data for certain enforcement priorities, but not others. And actually, it takes only a kind of passing glance at front page federalism news, which I follow, but won't blame anyone in the audience for not following, to notice that the most significant disputes, but also some of the most significant collaborations between our levels of government are increasingly about the functions and also like really the flaws of the intergovernmental data market. So I'll canvas just a few of those for you. In 2017, shortly after the 2016 election, President Trump announced a commission on election integrity And in this front page New York Times story, the newspaper prominently notes that embedded in the design of the commission is this sprawling data exchange program between the federal government and the states. So the commission sought voter registration information and personal data about virtually every registered voter from state election agencies. And the ostensible goal, at least, of gathering this data was to identify voters who were improperly registered or improperly voting in multiple states. But it was also ultimately this data exchange effort that was a kind of central player in the commission's downfall, because most states simply refused to turn over the information that the commission sought. It was ultimately shuttered. Likewise, if you've been following or were following the legal saga involving the census over the last 2 years, one of the major storylines was the Bureau's effort to collect citizenship data. After the Supreme Court, for a variety of administrative law reasons, prevented the Census Bureau from including a citizenship question on the census questionnaire proper, the Bureau announced that it would simply ask states to turn over citizenship data gathered by their DMVs. Again, raising controversial questions about whether it was an appropriate use of that state data for federal ends. For any New Yorkers in the room, you probably remember the kind of very public recriminations between President Trump and Governor Cuomo over the state's participation in the federal Trusted Travelers program. And this spat, like others, was at its core about the federal government's objections to being cut off in an unrelated program from New York's DMV data, which it relied on to conduct various immigration enforcement programs. So the threat to cut New Yorkers out of the Trusted Travelers program was intended as an inducement to get the state to reopen its data flows to the federal government. Of course, of great note to all of us, the administration of COVID-19 vaccines is deeply reliant on data. And if you've had a vaccine and you read the data acknowledgement that you received when you got your vaccine, you probably noticed that the state was collecting data for purposes of creating a state vaccine registry, and that the state would also forward that data to a federal database. But this process of creating a kind of federal database on vaccine distribution has not been smooth, in part because lots of states have raised concerns about whether the federal government, in its kind of haste to aggregate data so quickly, has implemented the kind of privacy controls that states ordinarily would expect for the stewardship of sensitive health information. Collaborations between the federal government and the states over data also make front page headlines. 2 summers ago, the Washington Post broke a story revealing that the FBI had signed agreements with 21 state DMVs to use their driver's license photos to perfect and deploy the FBI's facial recognition technology. And the total stores of photographs summed in the hundreds of millions. When federal and state legislatures learned about this program after its disclosure, there was great concern among legislators of both parties about the kind of progenation of this program, which stemmed from efforts by people within the FBI bureaucracy and people within state DMV bureaucracies kind of choosing to create this data sharing infrastructure without legislative authorization. So by understanding this market and how it's governed, by understanding how it has kind of innovated new forms of intergovernmental interaction centered on the sharing of data, the goal of this research is to sort of deepen our understanding of contemporary practices of American federalism more broadly by watching our system of vertically distributed power adapt to technological developments like the advent of big data, reveals how our system is responding for good and I think also for ill to the pressures of modern government. So I want to tell you a little bit more about the intergovernmental data market and then tee up some of the interesting legal issues it raises. And then hopefully in Q&A we can discuss the legal issues that are of particular concern to all of you. So within this data market, you see the federal government and states engaging in kind of one-off transactions. So think think back to the Voter Integrity Commission and its pursuit of a kind of one-time, although very broad, data dump from states. But our governments also engage in kind of repeat transactions. The federal taxing administrators and state taxing administrators annually exchange data to help each of them validate and verify tax returns. But what's most interesting, and I think of greatest concern to people who think about privacy issues and also people who think about federalism questions, is practices through which the federal government and states pool their discrete data into joint data pools, which both levels of government continuously add to, and which officials within each level of government can continuously draw from. So perhaps the biggest federalism program that nobody's ever heard of is the National Crime Information Center, which is an enormous intergovernmental data pool. So if you've ever been Terry stopped, you've had your license run through the NCIC, which consolidates data on daily police interactions from every law enforcement jurisdiction at every level of government in the country, and to which virtually every police officer in the country has access. So practices of intergovernmental data exchange generally, and especially of these data pools, present a range of legal issues. They present questions about privacy and how the rules that protect the privacy interests of the people whose data is deposited in these pools are formed. They present questions about administrative law, about how these data pools are governed across federal and state administrative agencies, and about judicial and political accountability. So just to see how legally complex these data pooling efforts are, it's helpful to understand how they sort of resist the legal frameworks that we use to understand ordinary collaborations between the states and the federal government, the sort of, you could call it paradigmatic federalism programs. So in the paradigmatic federalism program, you have the federal government and the states existing as distinct institutions, but deploying their governmental resources to common ends. So if you think about the Clean Air Act tells the federal government to set national air quality standards, and it allows states, if they want to be the kind of frontline regulator, so long as they're achieving those national air quality standards. But what's important is that the states and federal government continue to operate fundamentally as distinct governments. Intergovernmental data pools sort of resist this framework because once data is pooled, the government that collected it still retains an interest in governing that data, in ensuring its security, in protecting the privacy interests of their constituents, in ensuring that the uses to which the data is put are consistent with the views of that government's constituents. As a result, data pooling efforts represent a much thicker form of cooperative federalism than the standard cooperative federalism program. So to oversee these data pools, the federal government and the states literally create cross-governmental bureaucracies, which is a kind of legalistic term that I use in the article, but you can think about them too as kind of Franken bureaucracies, as combinations of federal and state authorities, and as administrative agencies that have a dual federal and state character. I also think about them as kind of existing in the interstitial spaces between the federal government and the states, but defying a kind of clean legal kind of either or legal categorization. So these cross-governmental bureaucracies author policies that govern data pools, and they jointly determine privacy entitlements for individuals with respect to those pools, and they together decide how data can be deployed. So they represent not just cooperative federalism, but kind of integrated federalism. And this integration is legally interesting for obviously several reasons, but one of them is that they aren't chartered by a federal legislature or a state legislature in the way that ordinary administrative agencies are. Instead, they're created by an unusual kind of legal device, which I've written about extensively elsewhere, which I call intergovernmental agreements. These are basically treaties for domestic intergovernmental relations. So the federal government and states want to pursue a project that requires deep integration in the way that data pools do. They basically sign a contract to structure their relationship. They enter into an agreement that serves as a commitment-making device, memorializes the consent of each party to join together, their meeting of their minds, their legal obligations and entitlements, and the things of value being exchanged here, data, between the two parties. So these intergovernmental agreements serve as kind of chartering documents for the cross-governmental bureaucracies that oversee and structure data pooling programs. So I'll just to make things a little bit concrete, I'll give you a couple of examples that I talk about in the paper. The biggest one, which I've already mentioned, is the National Crime Information Center. And over the course of this project, I've just become totally convinced that anyone who writes about cooperative federalism should be writing about the National Crime Information Center, because it is just phenomenally large and complex, a legally fascinating institution that blends federal and state power in really distinctive ways. I also look at another kind of cross-governmental bureaucracy in fusion centers, which are institutions that were created after 9/11 to fuse together data from the federal government, state and local governments, and from different parts of each government. Initially, fusion centers were created to blend together data for purposes of, for anti-terrorism purposes. But now they're used for many more mundane purposes, from things like disaster relief to even everyday policing, like tracking parolees. And finally, in the paper, I try to notice that cross-governmental bureaucracies can also arise from below, not just from above. And I document a kind of informal cross-governmental bureaucracy, a kind of line-level bureaucracy that's been formed over time through what are now routine, but still quite controversial exchanges of information between federal immigration agents on the one hand and state police officers sort of pounding the pavement together on the other. So what's interesting about each of these cross-governmental bureaucracies is that they mix together a variety of federal and state forms of authority. You can see my kind of quick and dirty a visual representation of these mixtures on the slide, but if you want to get into the details, happy to talk about them in the Q&A. But they mix together infrastructure, some located in federal buildings, some located in state buildings, sometimes located in joint buildings. They have a mixture of federal and state personnel. They envision governance structures and governance processes that allow for input between both federal and state officials, and they're funded, of course, jointly by the federal government and the states. I leave this box here for legal authority basically blank and basically neutral, because the one area that's the most difficult to comprehend is on what legal authority these institutions oversee these data pools. In part because they exist in these interstitial spaces, it's very challenging to trace their authority back to either the federal government or to the states. So you can consider fusion centers to see the story in a more concrete context. Lots of scholars sort of reflexively assert that fusion centers are agencies of state government. And that's significant for legal purposes, like who you sue if the fusion center violates your rights, and who has authorized the fusion center to exist and to use the force of the state, and through what body these centers are ultimately accountable. And it's true that there are over 50 fusion centers, roughly one for each state and a couple for large metropolitan areas. And it's true that we call them by their associated state names. So we frequently talk about the New York Fusion Center and the Nevada Fusion Center and the Florida Fusion Center. It's also decidedly true that they're not federal agencies. There's no federal enabling act. They're not subject to the Administrative Procedure Act, and they're not overseen by a presidentially appointed official. But when you start to press on what their legal authority actually is, you also notice that they're frequently, in most cases, not chartered by state governments either. Instead, the only source of their legal authority seems to be the intergovernmental agreement that creates the fusion center, which is typically entered into by some official in the federal government, normally a representative of the FBI and the Department of Homeland Security, and some official in state government. Could be a chief of police, but it could also be a kind of mid-level police manager. So in effect, these federal state administrative agencies, these cross-governmental bureaucracies, are really created out of kind of residual authority that exists within both the federal government and state governments. They're not specifically contemplated by either a federal legislature or a state legislature, which is how we ordinarily think about the creation of administrative agencies. But meanwhile, of course, they're funded and staffed and overseen by both federal and state officials. So in short, what matters is that the federal government and states, as they begin to pool their assets, here they're pooling data, but we can imagine in an increasingly integrated world, our government's pooling other assets as well. The lesson is they also have to restructure how they govern those assets in ways that can defy even our most basic kind of con law 101 understanding of federalism, that federalism distributes power between governments, because here instead we see our governments blending their power in sort of innovative ways. So before opening the floor to questions, I'll just pause to mention a couple of theoretical implications of the piece, although there are many more also. One is that we're told over and over by the Supreme Court that federalism is a system that divides power between levels of government in order to protect liberty. Federalism is a system that is intended to guard against the harms that stem from the concentration of power. But the intergovernmental data markets that I'm documenting here kind of turn that rationale on its head, because data transactions and data pools don't diffuse power between government, they allow for the concentration of data power. And then they take the further step of diffusing access to those concentrated data pools to governmental officials throughout the country. So we see federalism acting as a power multiplier instead of as a power divider. We also routinely see in doctrine federalism justified as a way of creating clear accountability structures. But here again, the intergovernmental institutions that our governments have created to oversee their joint data pools serve often to obscure accountability, to unmoor these administrative institutions from either federal or state forms of accountability, and to leave them kind of administrative states on an island. So federalism, in short, has clearly adapted to technologies in ways that disrupt standard federalism, standard conceptions of how federalism works, but also some of the core justifications for federalism. So to understand data federalism then is to have to confront anew what our system of federalism does and how it serves or perhaps even undermines the constitutional values that federalism is designed to advance. So on that note, I'm going to open the floor to a broader conversation, and I believe there are, you can put your questions into the chat and I will be delighted to answer them. Okay, let's see. Okay, so the first question is, where can the public see the terms of these intergovernmental agreements? And that's a terrific question. These intergovernmental agreements are ordinarily not made public. Some agencies of state and federal government do make them public. Some of them are covered by state sunshine laws or the federal FOIA. You can see some of these agreements by emailing me and asking me to send you some examples. They're sometimes attached to litigation documents. I've obtained many of them through FOIA requests and by general sleuthing practices. But one of the, I think, concerns about these agreements is that unlike federal laws, state laws, federal regulations, state regulations, city ordinances, there's not a presumption of transparency with respect to these agreements. They're much more, they exist much more in a kind of the sort of legal frame we think about for contracts between governments and private parties, because that is, they kind of have a contractual form, but this presents a real problem for thinking about their legitimacy, because most people can't see the terms that are affecting, in the case of data, some profound rights to privacy and security. Okay, let's see. Great, so the next question is about the tracking of police abuse cases. And This is actually a really interesting question. There is a federal statute that creates a federal database that would, through the intergovernmental data market that I talk about here, collect information on police abuse. But that database has never been funded by Congress, and so states have never been given an inducement sufficient to cause them to contribute to it. So there is an infrastructure, and part of what my paper and this project tries to show is that there's really no excuse for not having that database if there's political will, because we have so many intergovernmental data aggregation efforts. So I think the conclusion with respect to that database is it's one of political, it's an issue of political will instead of technological kind of capacity. The other part of the question is whether the NCIC could be used to track these incidents. It could certainly serve as the infrastructure, but you know, the federal government would still rely on state governments to send in the data, and that hasn't to date been accomplished. Okay. Yeah, so the next question talks about U.S. Treasury and state tax departments sharing data through intergovernmental agreements. And the question is, what benefits and issues have you identified with respect to the sharing of tax data? So this is an intriguing question, because going into this project, one of my hypotheses was that intergovernmental data sharing is not generally subject to kind of legislative discipline, that a lot of it happens like the FBI DMV program at the initiative of lower level administrative agents. And but I was also aware that tax information has been shared with the express structuring of Congress for a long time. So my initial thought was to think about that as being a kind of counterpoint. Here's an area in which we do have legislative oversight over data sharing, and we can kind of learn from it. But one of the things that I noticed is that although the highest level rules for interstate tax information sharing are set by Congress and state legislators respectively, most states also have further, more detailed bespoke agreements with the federal government that kind of customize the data sharing structure specifically for that state. I've read some of those agreements, but I'm not a tax specialist. I think it would be a phenomenally interesting project to look at what different kinds of terms different states have been able to negotiate with respect to the data sharing. So it turns out even in the tax world, which I would have thought was very disciplined and guided by Congress, there's still quite a bit of involvement, quite a bit of administrative discretion on both the federal and state sides. Okay, let's see. Yeah, okay, so the next question is about the circumstances under which states can say no to intergovernmental information sharing. And you see the example of the Election Integrity Commission, to an extent, the census effort to get citizenship information from state DMVs. You see a lot of states exercising that right to say no. One piece of the paper, which I didn't include in the talk, but I'm happy to talk about, is the doctrinal piece. There are some rules that the Supreme Court has for the formation of voluntary cooperative federalism programs. One of those rules is that the states have a right not to participate. And another rule is that the federal government can't coerce states to participate. And part of what I do in the paper is argue that those rules do apply to data programs, which is something there's been a little bit of debate around. So I certainly think the federal government and states can say that the states should be able to say no to federal requests to share data. And the other part of the question is about whether a congressional committee or an administrative agency can simply subpoena the data. In cases where a state has a constitutional requirement under the anti-commandeering rule not to have its data commandeered, I think that that right would allow the state to resist a subpoena as much as it would allow the state to resist any other form of request for that data. There was close to a test case of this last year when the federal government upset that sanctuary cities weren't turning over immigration information, sought to subpoena that data from a couple of state and city law enforcement agencies. I believe Denver resisted the subpoena on constitutional grounds, and the case ultimately kind of fizzled out. But I think had the policy been continued, and I don't think it has been continued in the new administration, I think we would have seen that kind of rise up into a test case of that. Okay, so yeah, so the next question is about the CODIS DNA database. This is a database that's networked with the NCIC, and it includes DNA from a wide range of states. And certainly that is the question is this an instance of the pooling I'm talking about? Yes, this is an instance of the pooling I'm talking about. And actually, even more than tax information, this is the rare case in which legislatures are quite involved. I think owing to the sensitivity specifically of DNA data, Congress has a very specific set of rules that govern who within states can add DNA data into the federal DNA database. It has to come from specifically certified labs. But this is a kind of exception that proves the rule about legislative oversight. So many of these programs are never mentioned in a statute anywhere, and are the kind of imagination of administrative officials. DNA is an example that shows that what legislatures could be involved in structuring this data sharing, but they just often choose to take a back seat. The next question asks about the interaction between these data pools and federal and state Freedom of Information Acts. I really like this question because in the process of researching this paper, I had to become very acquainted with federal and state Freedom of Information Acts. You can gain information sometimes about data pools through FOIA and state sunshine laws, but really not always. For instance, fusion centers, because of operation of state law and also terms in intergovernmental agreements, have in effect kind of contracted around some state Sunshine Act protections. So a standard provision in fusion center intergovernmental agreements is the agreement to give the FBI a veto over the disclosure of any information produced by the fusion center, which has the effect of preventing a state from disclosing under a state sunshine law information that the FBI would prefer not to have disclosed, even if it's information that legally should be disclosed by the state. So you have to take it institution by institution, but the general principle is that the blended legal character of the institutions that oversee these data pools also leads to a great deal of legal uncertainty about whose laws actually govern these data pools and the actions of the agencies that oversee them. Are there any examples of states sharing information with other states or groups of other states and leaving the federal government out of the process? Yes, there are. There's a great example in the voting context. There was a program called CrossCheck created by the state of Kansas, but ultimately at its peak, I think it had 25 state participants. And its structure was state election officials could submit lists of their voter rolls to the state of Kansas, and Kansas would then cross-check them against voter rolls in other states to identify people who were registered to vote in two states. The cross-check program was incredibly controversial, in part because it was so informal in the way that it handled the data that it received. It received data that included things like social security numbers and just stored them on like truly kind of random servers. So there were real privacy issues that arose. There were also voting rights issues that arose because states were taking the indication of a matched name between a voter registered in one state and a voter registered in another as a reason to cull that voter from voter rolls, and that for reasons particular to voting rights law is not a sufficient basis to remove somebody from a voter roll. So the program was ultimately scrapped, but then it was reconstituted in a program called ERIC, which is a joint state effort, so it's not housed within any one state, that tries to do the same thing, but to comply with more robust security and privacy standards. So the next question is whether there's any congressional oversight or state legislative oversight of the operation of intergovernmental agencies. There certainly is to a degree, but I'm not convinced that either the federal government or state governments really understand how these agencies fully operate, in part because they've been structured in, kind of through accretion and, through these, beginning with these intergovernmental agreements, and then the specific processes are often just negotiated by the federal and state participants. And as a consequence, the federal government might oversee the federal government's employees who participate in fusion centers, for instance, and subject those employees to a range of training and accountability requirements. But those oversight mechanisms kind of stop where that person kind of passes off information to a state counterpart. And so there can be this kind of gray area, right, in the collaboration, sort of no matter how much you discipline an official who enters into this agency from one side, if you don't actually look at what that person's doing within the agency or how their actions are setting in motion other actions by state officials, it's hard for a kind of federal legislature to truly get a handle on what's going on within these agencies. There's a riveting congressional oversight hearing involving the FBI DMV photo sharing program, in which congressmen on both sides of the aisle were just aghast that they didn't know that this was happening. So there's also a true element of surprise frequently for legislators when they learn about these programs, and not in a good way. Okay. There are a number of intergovernmental agreements among federal, state, and local agencies enforcing anti-discrimination laws. They are mostly about which agency proceeds when and the impact of one agency's decision on the other. I'm not aware whether any deal with data collection. Have these been studied? So intergovernmental agreements. So in my last paper, I write about intergovernmental agreements in the data world and in other contexts. And this question is totally right, that intergovernmental agreements are a core tool used to enforce Title VI of the Civil Rights Act, which prohibits discrimination in any federally funded program, whether it's a contractor who receives federal funds for a contract or a local school board, which receives federal funds for education. And often it's the intergovernmental agreement that is the kind of jurisdictional hook for the federal government to be able to hold the state or city to its agreement not to discriminate. And I'm not sure what kinds of data are incidentally kind of transmitted in the course of enforcing Title VI, but it would be interesting to look at. Yeah. The next question is about similar agreements between federal or state governments and private companies, and whether they exist and what would be the consideration. Both the federal government and states and cities, so all three sets of governmental actors, have close relationships with private technology companies for data sharing. So the federal government relies heavily on private sector data providers in its immigration enforcement. It buys effectively Facebook data and internet search habits about people that can assist it in some of its investigative tasks. So that certainly happens. With respect to facial recognition, the FBI was working closely with a private facial recognition contractor to develop that facial recognition program. So everything I document in this project, you could have a parallel project that looks at interfaces between the public sector data market and the private sector data market. And the big thing I would say is, we should all, if we're worried about data aggregation, we should all be worried about a state putting into, for instance, its law enforcement databases, a bunch of private sector data, because that data is very likely not to remain in that state alone. Because of the intergovernmental data market, it's likely to be diffused throughout federal, state, and local governments and accessible to all of them. What would the consideration be? Often private companies are just contractors. I'm not aware of any cases in which the federal government or state or local governments have offered data as the consideration in exchange for data. So in the intergovernmental context, often in the NCIC, the federal government puts in the data, it has, states put in the data, they have, that's the mutual consideration. In the private sector, I think they're financial transactions. The next question actually is related, which is about data pools that are formed by private companies, but that include public data. So this is, data scrapers might be able to get data from court records and put it into one place. That's true of voter data. You can assemble databases from voter data with enough effort. And this question specifically mentions automobile licensing information. Yeah, so there used to be actually quite a bit of data selling to the private sector from governmental entities. So in the case of voter registration information, the information was just made public, and then people with the technological capacity to scrape for it were able to put it into their own databases. With respect to driver's information, it used to be an extremely common practice for state DMVs to sell information to marketers. A federal statute called the Driver Privacy Protection Act prohibited that selling and gave rise to a actually great Supreme Court case about whether it was appropriate for the federal government to tell states who they could sell their data to, whether they could sell their data to private entities. So that DMV data sharing is less common, but like in so many other areas, regulation lags activity. So DAPA took a long time to catch up to the practices of states trying to monetize their data. So it's not surprising that Congress, really I should say, legislative oversight has taken a long time to catch up to the practices I document in the article. Let's see, follow up. If you look further into tax sharing, don't forget to check out the Multi-State Tax Commission, which operates under the Interstate Compact provision. Yeah, so I'm glad you asked this question. It's a future research project, which is to explore further data sharing horizontally among the states. So I mentioned CrossCheck program and ERIC, and the Multi-State Tax Commission is another example. During COVID, there's been some very interesting, primarily informal practices of data sharing among states for purposes of tracking COVID cases in states where you have people traveling back and forth with some frequency. So I think that there in the same way that there is a really interesting parallel project about the interfaces between the intergovernmental data sharing market and the private data sharing market, there's also a parallel project about the horizontal data sharing market between states. So great question. Have you been able to determine exactly what data each center is aggregating and how the various data aggregation centers use the data, including tax? Is there any transparency? I think transparency would not be an appropriate word to describe how much we know about what data each center is aggregating, even where you can read the Intergovernmental Agreement, which roughly specifies what data the states are sharing and the federal government is sharing and what data is being received. It's not at the kind of granular level that, that you would need in order to know something real about the data. It's quite high level. This is also true for the federal. So the Federal Privacy Act requires federal agencies to disclose circumstances in which they share data with anyone, but the disclosures are at such a high level of granularity. They just say, we are disclosing the data we have with the state of Connecticut, say. So they're at such a high level of granularity that it's incredibly difficult to understand what data is actually there. In the taxing world, we have more understanding because there is at least a federal statute on record which specifies different categories of information that can be shared. But then there are also these individualized agreements that the federal government and states enter into to fill in the gaps of those statutes, and it's not clear what data those agreements, specifically what data those agreements mention. When you subscribe to many services, you're forced to accept use of your data, small print. What are usually the legal ways to protect such data from being misused? So the United States doesn't have what's called an omnibus privacy bill. We don't regulate in the way that the GDPR, if you're following European politics, regulates data use. So most likely your rights with respect to how that data is used are a product of state law. Some states are better than others. California has relatively robust privacy restrictions, but it's certainly a small minority of states that do have something like a state level omnibus data regulation infrastructure. The United States has what privacy scholars call a sectoral approach, which means that we have statutes that talk about specific kinds of data. So HIPAA is a statute that regulates health data. For my purposes here, one of the things that I think is very notable is that in almost every sectoral statute that applies to data collected by the government rather than private parties, which also often includes the notices that you're mentioning, there's an exception for intergovernmental data sharing. So in general, these statutes just, allow reasonable uses of the data, and it's considered a reasonable use to send the data collected by the federal government to state governments or data collected by state governments to federal governments, whether or not we would all think that it's reasonable for our DMV photograph, for instance, to be used for various, federal criminal law enforcement purposes. Ordinarily civil data is not used for criminal purposes, but because we don't have protections that keep data use to the government that collected it, and because what data is used is just negotiated between the governments in these one-off agreements, you often see quite broad expansions in the way data can be used. Have you found or proposed any best practices for the use of such shared data? Probably good for the NCIC to let every state and federal law enforcement know that somebody is wanted for murder, but a lot more is being shared beyond that easy call. Yeah, so my first concern in this paper is to suggest some procedural reforms that we might use to make the agencies that oversee this data look much more like standard administrative agencies, to subject them to the legal frameworks and procedural accountability mechanisms that agencies within the federal government and within the states are subject to under things like the Administrative Procedure Act. and to also make the work and structure of these agencies much more transparent so that they can be subject to kind of legislative accountability. So I think the first step is a sort of procedural step, so that the people whose data it is can actually follow their data through these intergovernmental exchanges. Because right now, if you wanted to know where the DMV photograph that is on file with your state DMV is, it would be impossible. Like, I could probably, take an educated guess at where your photograph is and what various governments can access it and for what purposes. But it would be very difficult to try to, know with certainty how your data is being used. So I'm very interested in first procedural reforms that help bring some transparency to these questions. There is a widely accepted set of data management best practices that include things like you shouldn't collect data for purposes you should use data for the purposes for which it was collected. So if you collect data for the purposes of licensing drivers, you should use that data just for the purpose of licensing drivers. That's a kind of data management best practice that's been recited by governments and organizations for really since the kind of advent of the computing age, and which is needless to say not hewed to with respect to intergovernmental data sharing. So I also would encourage a policy of notice, at least informing people of what the uses of their data might be when that data is collected. Let's see. Does purchasing the data always come with access rights to corrected data or updated data? This is a major question in the NCIC because criminal records are always being updated. The big controversy in the NCIC is that arrest data, when a person is arrested and booked, their fingerprints and the fact of their arrest are automatically entered into the NCIC. This is true of every single jurisdiction that participates in the NCIC program. Although different states and different cities have negotiated different kinds of arrangements with the NCIC, it's true of all of them that when a person is arrested, the arrest goes into the NCIC. But states have quite varied practices for putting information about the final disposition of the person's case into the NCIC. So almost the inverse of what your question is asking. One of the big controversies is it's really not fair to put arrest information into the NCIC unless you also include information about what happened to the arrestee. Were they later released? Were they later charged and found guilty? Were they later charged and found not guilty? So there's much more variation in the amount of information that we have to tell us what to read into the arrest information, and instead we have this kind of thin information that doesn't kind of tell us enough. It is true that when states update their criminal history records, frequently the NCIC is updated. But one exception that I'll give, which I became very interested in researching this project, is expungement. So you would think that if a state expunges a crime from a record, that expungement would also appear in the NCIC. But the NCIC, for reasons that have to do actually with federal statute that governs the National Archives and the need of federal agencies to deposit their data in the National Archives, has negotiated with the National Archives a 20-year retention frame for all of the data it has. So if a person has a record expunged from their criminal file, it will stay with the National Archives for 20 years because of this kind of strange federal record keeping requirements. So those are the kind of unexpected consequences that can make it hard to rationally govern some of these programs. So the next question is, the FBI asked states and local governments to report killings by police, but the request is widely ignored. Would the current Supreme Court uphold a federal directive, say by an act of Congress, or would the no commandeering rule be invoked to negate it? So I don't think constitutionally that the federal government could mandate that states report information on killings by the police to the federal government. However, the federal government could say a condition of participating in the NCIC, which every state policing agency depends upon for its daily policing, is that you report killings by the police. So I think it would be, it would, as the question says, I think it would be unconstitutional commandeering to require it, but you could condition participation in the program on not just, for instance, sharing information about people who are arrested, but also sharing information about the people doing the arrest. That would be a totally reasonable condition to place on participation in the NCIC. Okay, how does the reality of identity theft play out in this data collection and sharing? Well, I can think of a couple of different ways that identity theft might play into the equation here. One of them is when you take data and filter it through lots of institutions and lots of points of access, you raise real security concerns. And it's certainly true that data shared by states with the federal government has been compromised in hacks of federal databases and vice versa. The data shared by the federal government with states has been compromised in hacks by state databases. Intergovernmental agreements in general are not very good at negotiating robust security measures for the data that is shared. Some are better than others, but frequently they include language like use best efforts to ensure the security of the data. Which, you know, anyone here who's drafts contracts knows is not likely to get really robust data security. So one just basic concern is as for instance, our DMV data is kind of filtered through lots of governments for lots of purposes. It also creates totally separate from the legitimate aimed purposes that governments are putting that data to, lots of security risks that I don't think we've fully, that we have a good infrastructure for combating. Are there third-party beneficiaries to these intergovernmental data agreements? If so, what are the customary agencies that could benefit from such a clause? I love this question because in my article on intergovernmental agreements, which is called Federalism by Contract, if anybody's a glutton for punishment and is really in need of more information on these questions, I have a section on third-party beneficiaries of intergovernmental agreements. So I teach in addition to teaching structural constitutional law, I teach contract law. And so of course, everybody remembers from contract law that although there are third-party beneficiaries to contracts, they exist only in relatively rare circumstances. They're the exception, not the rule. And that's also true in the intergovernmental context, but kind of puzzlingly, because intergovernmental agreements are the paradigmatic case of the creation of third-party rights. They exist to establish governmental programs for the benefit of not the governments themselves, but the constituents of those governments, for the people whose data is the subject of these intergovernmental data sharing agreements, for instance. So there is some Supreme Court case law about this, and third-party beneficiaries are generally disfavored in the intergovernmental agreement context, but there are some available strategies to get third-party interests more adequately represented that largely, to my great delight, turn on contract law and not on constitutional law. So, so this is the fun area of intersection between private law and public law that I not only teach in, but also write in. I think I'm being told that we are right at the end of our time. So I will say thank you for joining me. And if anyone wants to continue this conversation, you can find my email address on the University of Chicago website. And I hope you enjoy the remainder of your alumni weekend.